Welcome to this webinar. It's the second of the two-part series of data management basics, and it is related to ethical and legal issues in data sharing. My name is Hina, and I am a senior research data officer at UK Data Service, and we are based at University of Essex. I am mainly responsible for overseeing ethical and legal issues within the data management team at UK Data Archive. In this webinar, I aim to cover the following. The overall aim of this session is to show how you can share research data from human participants within ethical and legal boundaries. The first section focuses on the ethical obligations in data sharing. In this section, I'll briefly discuss the key principles of research ethics. I will also talk you through some of the ethical considerations and best practices in data sharing, including research ethics self-assessment tool. The second part of the session focuses on the legal compliance when sharing data. In this section, I will talk you through to the duty of confidentiality, data protection considerations, and some strategies for managing and sharing research data that includes disclosure, assessment, anonymization, consent, access controls, and I'll also touch on copyright considerations and some of the best practices to be legally compliant when sharing data. Finally, I will show you some of the useful resources we have got and respond to the questions in the end. So research ethics governs the standards of conduct for scientific researchers. It is important to adhere to ethical principles in order to protect the dignity, rights, and welfare of research participants. ESRC and UKRI has set out key principles for ethical research. These principles are the following. For example, researchers should ensure that their research is beneficial to participants, individuals, science, and society, and be realistic about the benefits that it is likely to deliver. Research should be designed and conducted in a way that respects the rights, interests, values, dignity, and autonomy, if possible, of participants, including individuals, groups, and communities. And ethics issues are most likely to arise around privacy, equality, diversity, and health and safety. So researchers should inform participants that they have a right to refuse to participate and free of consequences and can withdraw from the research for any reason. Integrity demands that there is a clear fit between what researchers say they will do and how they will conduct their research. Transparency means being clear about the nature of the research and communicating this to those involved. Researchers must exercise self-critical responsibility in the planning and conduct of their research. Research ethics committees and research organizations have a responsibility to guide and support researchers, especially when the research involves difficult ethical decisions. And researchers should maintain the independence of their research, and where conflicts of interest cannot be avoided, they should be made explicit. It should be free from any personal and political bias, dishonesty, and considerations of gain should be safeguarded at all times. It is important that researchers do not just consider what can be done with the data, methods, expertise, and technology available to them. It is equally important that researchers consider what should be done. So National Statisticians Data Ethics Advisory Committee provided a framework to help all researchers to think about the ethics of their research at an early stage and give them confidence that their plans consider and address accepted ethical principles and practices. So they have designed a very useful ethics self-assessment tool to review the ethics of the project to be undertaken. And This tool enables to identify and mitigate any ethical issues. It is based on 6 main principles, and these main principles are public good, confidentiality, data security, methods and quality, legal compliance, public views and engagement, and transparencies. And when you're using that tool, you are asked to assess your project against 22 items grouped against these 6 ethical principles on a scale. So it is beyond the scope of this session to go into further details of this tool, but please go and have a look into it as it is a really useful tool. I have inserted the link to this tool at the end of the, at the very last slide in further resources. So some of the best practices are that ethical obligations should be considered throughout the research life cycle, from planning and research design, data collection stage to the future use, including publications, archiving, sharing, and linking of data. It is essential to have a knowledge about the standards and requirements of the relevant research organizations. Always comply with the relevant laws, avoid social and personal harm, and you can always check with the data centers like UKDS, as they always facilitate ethical and legal reuse of research data, protection of participants, and safeguarding of personal data. So now I will talk you through some of the legal issues or your legal compliance when sharing data. In the UK, there is a duty of confidentiality that is based in common law, and that occurs where confidential information comes to the knowledge of a person in circumstances where it would be unfair if it were then to be disclosed to others. There are some exceptions when you can disclose information. For example, if participant consents to onward share their personal data, then sharing does not breach duty of confidentiality. Sometimes public interest can override duty of confidentiality. And occasionally, there are instances when you may need to give up data, such as if you are getting a court order. So the best practice is to avoid very specific promises in consent forms. As researchers, we must adhere to data protection requirements when managing or sharing personal data. So if personal information about people is collected or used in research, then the data protection regulation applies. Personal data is any information relating to an identified or identifiable natural person. People can be identified directly or indirectly. And examples of direct identifiers are name, address, postcode, telephone number, or biometric data. And some of the examples of indirect identifiers are occupation, geography, or some unique or exceptional outliers. Data protection legislations that are most widely applicable to the research are Data Protection Act, GDPR, and now, which is now the EU GDPR is now known as the UK GDPR. EU GDPR is the EU-wide data protection regulation that was introduced in 2018 and replaced UK Data Protection Act 2018. So that was used until that time. However, since January this year, when the transition period of Brexit ended, it is now called the UK GDPR. Currently, the UK GDPR and the GDPR are aligned. They place the same legal obligations on researchers, but in the future, the two pieces of legislation may diverge. As the UK has now left the EU, it will therefore be important for researchers to ensure that they gain local support from their university data protection officer when their research project will span across the European Union. So now, if the researcher is based in the UK and collects personal data about people anywhere in the world, or a researcher outside the UK collects personal data on UK citizens, then DPA and UK GDPR applies. However, if the researchers are undertaking research projects which span across the Europe, then GDPR will also need to be considered and adhered to. UK GDPR specifies the rights a data subject has when their personal data are processed. Individuals have the right to be informed about the collection and use of their personal data. They have a right to access the information you hold, and they can request any change in the information, ask for erasure, object, or ask to restrict processing altogether. They can also object in terms of data portability or transfers to any other country and any sort of decision making. They should be involved in that. Which of these rights will be relevant to processing personal data for your research project will depend on the nature of the project, the chosen processing ground, and in which country the research is taking place. The Data Protection Act and the UK GDPR define 6 principles that need to be complied with when processing personal data. All personal data must be processed lawfully, fairly, and transparently. It should be kept to the original purpose. Personal data should only be collected if it is necessary and removed if it is not necessary. Accuracy should always be upheld, and researchers should ensure confidentiality and integrity. So under the UK GDPR, as well as the EU GDPR, there are 6 possible grounds for processing personal data, and one of these must be present. These are consent, public interest, legitimate interest, protection of vital interest, legal obligation, and performance of a contract. In the context of research, the first 3 are the most applicable grounds for processing of personal data, and consent is likely to be the most widely used ground for processing personal data in the UK. So there is a misconception that data protection laws such as GDPR prohibits data sharing. However, it does not prevent data sharing as long as you approach it in a sensible and proportionate way. GDPR is useful for research. It legalizes much of the current good practice in research. Placing people at the center, GDPR offers enhanced rights to individuals whose data is being processed. In the context of research, GDPR has the potential to further benefit research and archiving, helping to improve trust and confidence between the public and universities and between researchers and their participants. So much research data, even sensitive data, can be shared ethically and legally if researchers employ certain strategies. For example, offering protection of identities through anonymization, de-identification, using personal ground for personal data, for processing personal data, regulating access where needed. They can restrict access to all of the data or part of the data by group or by time, and putting safeguards and security. So first of all, if you need to keep the identity of the research participants confidential, then the risk of disclosures need to be considered before, during, and after the data are collected. Assessing disclosure risk is done by evaluating key characteristics or variables in data files that are the most risky for leading to participants' identification in a specific project. These can be direct identifiers, for example, a person's name, national insurance number, picture, or detailed geographic location, or indirect identifiers that can provide enough information to identify someone in combination with other, for example, large household size, specialized profession, unusual health conditions, or any unique or exceptional values or characteristics. So once disclosure assessment has been completed, relevant strategies such as anonymization, de-identification, consent, or regulation of data access, can be employed for processing personal data for future reuse. I'll go through each of these strategies briefly to show how these enable to share your research data. So, researchers need to consider how to protect identity or confidentiality of the participants when sharing data in both quantitative and qualitative research. Anonymization or de-identification is the tool that allows data to be shared while preserving privacy. As stated earlier, identity can be disclosed from direct identifiers or indirect identifiers, which, when linked with other available information, could identify someone. So, to anonymize data, the most widely used techniques are de-identification and anonymization. De-identification is removing direct identifiers in personal data, while anonymization is ensuring that the risk of somebody being identified is negligible. So, anonymization should be planned early in research. Some techniques used for anonymizing quantitative data may include removing direct identifiers, such as removing names or replacing them with codes, aggregating categories to reduce precision, for example, birth year versus date of birth, restricting upper or lower ranges of variables to hide outliers, generalizing the meaning of detailed text. For example, detailed areas of medical expertise could identify a doctor's expertise. Variable could be replaced by a general text, such as one area of medical expertise. So, restricting upper, lower ranges of a variable to hide outliers. So, best practices for anonymization of qualitative data should involve the following. Plan anonymization at the time of transcription or initial setup. However, longitudinal studies may be an exception. Use pseudonyms or replacements that are consistent within the research team and throughout the project, and even in publications and follow-up research. Identify replacements in text clearly, for example, with brackets, creating an anonymization log of all replacements, aggregations, or removals made and store such a log separate from the anonymized data files. And you can have a detailed and further information relating to anonymizing quantitative and qualitative data from our website. I have inserted this hyperlink at the bottom of each slide where you can go and have a look. In some instances, anonymization is not possible, so either consider obtaining consent for sharing non-anonymized data, or as a last resort, regulate or restrict user access. Next, I'll go through each of these briefly. I'm sure you all are familiar with what informed consent is. However, when it comes to data sharing, then consent is used for two purposes. We are all familiar with the consent that is used for research participation and is considered as one of the founding principles of research ethics, where it is sought before participation in any research activity and for all participants. It usually involves providing information regarding study purpose and risk, benefits, and about voluntary participation. However, as stated earlier, consent can be used as one of the legal basis of processing personal data under UK GDPR. If a researcher collects, manages, and shares personal data, then consent of the data subjects can be used as a legal basis to process this personal information. If consent is used as a legal basis for the processing of personal data, then there are certain conditions that needs to be met. These are: consent must be freely given, informed, unambiguous, and it should be specific. There should always be a clear affirmative action, and it should not be inferred from silence, pre-ticked boxes, or inactivity. It should also mention about right to withdraw. participants can withdraw their consent for processing personal data. This is different from the right to withdraw from the research. It must be documented, should be either recorded, written, or oral. If you are dealing with special category data, then there must be an explicit written statement. Consent can be gained in written or oral form. The format of the consent depends on the kind of research. However, it is important that whatever format is used, written or verbal, it should be documented. You need to document how it has been gained, what information has been provided to the participants, and what they have agreed to. Consent can be written on verbal. Both formats have pros and cons. For example, written consent has more solid legal ground. It shows that participants have agreed to disclose confidential information. This is the form that is usually required by ethics committees, and most of all, it offers more protection for researchers as they have written evidence of consent. However, it cannot be used in some instances, such as any illegal activities. On the other hand, verbal consents are best if recorded, but sometimes it is hard to make all issues clear verbally, and most of all, it can pose greater risk for researchers in regards to adequately proving participant consent, or it may scare people from participating and have them think that they cannot withdraw their consent. Typically, written consent documentation includes an information sheet and a consent form signed by the participants. This division allows the background information to be as detailed as necessary while keeping the signature form short and concise. So, an information sheet should cover the following: the purpose of the research, what is involved in participating, benefits and risk of participating, procedures for withdrawal, future uses of data such as storage, publishing, archiving, and details of the research, funding such as funding source, sponsoring institution, name of project, contact details for researchers, and how to file a complaint. Researchers need to make sure that consent form should use simple language and should allow the participants to clearly respond to points such as they have read and understood information about the project, they have been given the opportunity to ask questions, and they voluntarily agrees to participate in the project. They understand that they can withdraw at any time without giving reasons and without penalty, and they understand the future uses of this study, such as publications, data sharing, and data reuse. And signatures and dates of signing for the participant and the researcher should be there. So if personal information is collected, best practice is to provide information about how personal information will be processed and stored and for how long. Procedures for maintaining confidentiality and whether real names will be used or not, if data will be anonymized, if so, how. It should also state procedures for ensuring ethical use of the data, especially in the context of archiving and reuse. If the GDPR applies, then further information needs to be provided in the consent form, such as the contact details of the data controller. And data controller is the entity that determines the reason for processing personal data. It could be a data protection officer, research ethics officer at your organization, or the researcher yourself. Consent form should also state who will receive or have access to the personal data. It should also have a clear statement on the rights of the participants, because participants can request to access their data. They may ask for corrections or removal of their personal data. These need to be communicated to the participants. However, you may use some in the information sheet and some in the consent form. So please have a look at UKDS model consent form, where you can find detailed guidance along with the templates to get a clear understanding. Obtaining consent for participation in research. or for future use, such as publication or sharing and reuse of data, can be a one-off occurrence or an ongoing process. Both approaches have advantages and disadvantages. One-off consent is used for taking part in the research project only once, and it is simple and the least hassle to participants. But there are disadvantages, such as sometimes research outputs are not known in advance, and the participants will not know about all the information they will be contributing to. On the other hand, process consent is requested continuously throughout the research project. It ensures active consent, but it may not get all consent needed before losing contact, and it can be repetitive for participants and they may be annoyed. Yeah, so sometimes researchers do not consider obtaining consent for future uses of data, specifically archiving and sharing. In that case, they may consider retrospective consent. However, if a participant cannot be traced, the status of publishing or sharing the collected data may be uncertain. But always bear in mind that there is an option of getting a retrospective consent. So as I mentioned earlier, if it is not possible to anonymize data, then you can consider obtaining consent. However, sometimes this is not possible too. In that case, you can restrict user access. You can still share data, but you can restrict who is going to use your data. So for example, here at UK Data Service, we facilitate 3 levels of access for data. Open access for data that contain no personal information, safeguarded access for data that contain no personal information, but the data owner or researcher considers a risk of disclosure resulting from linkage to other data. It is available under end user license, and users need to register to access data. Users also need to agree to certain conditions, such as not to disclose any identifying information. And then there is controlled access, which is for the data that may be disclosive. Controlled data are only available to users who have been trained and accredited, and their data usage has been approved by the relevant data access committee. So access is through a virtual or physical secure environment, and access varies according to user type, location, data access conditions, and project type. And it can also be tailored. For example, mixed level of access control may be put in place for some data collections, combining controlled access to confidential data with standard access to non-confidential data. So if you are planning to use secondary data sources that are already available, then you need to consider copyright issues. Copyright or IP rights are assigned automatically to the creator or the researcher who owns the data. So when data are shared or archived, the original owner retains the right. Data archive cannot archive data unless all right holders are identified and give permission for their data to be shared. So information being in the public domain just does not mean copyright does not apply. So if you are using secondary data sources, then best practice is to assess who the copyright holder of the data set is. Are you allowed to use them, and in what way? Are you allowed to archive and publish the data in a data repository? Most of the time, we encounter problems when researchers are allowed to use data as the data is under open license, or they just register to use it or pay it to subscribe, pay a subscription to use that data. But what they do not realize is that it is accessible to them for their personal use, and they need permission from the data owner for sharing it or archiving it. So you may need to seek further permission to distribute material you do not own. If permission is not granted, you need to remove copyrighted variables before publishing or sharing. So to be legally compliant, always investigate early which laws apply to your data, including cross-country collaborative working. Do not collect or keep personal or sensitive data if not essential to your research. Plan early on, seek advice from your research office, ensure that you check participants know how this data will be used. And remember that not all research data are personal. If it is anonymized, then it's not personal data and it is not a problem to share it. So here I have added some of the very useful resources for you to have a look into your own time. And it includes a model consent form from UK Data Service, example consent forms and example information sheet. And then there is a very useful consent form visit recently introduced by Daria, and the legal rights when using secondary data sources and more information about regulating access to data. And then there is an online book available, which is all about managing and sharing research data. So these are some of the upcoming events which could be useful for you, specifically consent issues in data sharing, where I would go into more details and I will discuss the UK Data Service model consent form and real example consent forms from researchers. And there is another event coming up, depositing your data with Reshare, where my colleague Anka will go through how to deposit your data into our self-repository called Reshare. And I have added a link to the anonymizing quantitative and qualitative data webinar, which was, I think recently, like 2 weeks ago, but you can go and check. So thank you for attending this session. If there are any topics related to ethical and legal obligations in data sharing that you want us to include in our future training, I would like you to add these to the question and answer box. And I would also like you to ask if you would like to share what do you usually struggle with in the context of research ethics and legal compliance. If you want to write it in the question and answer box, that would be great. And yeah, so I have also added here in this presentation the UK DS model consent form, and not the real examples, it's just because of the time I have just added UK DS model consent form. So I let you read this consent template from UK Data Service. It's a screenshot of one section which is related to the taking part in the study. I let you read it first. So this section is all about taking part in the study. Here you can see that conditions of the consent form I mentioned earlier have been addressed. Like participants are asked to, they are ticking the box that they have read and understood the study information. They are taking part in the study voluntarily. They can withdraw at any time. And then they are informed how their information is captured and what could be the potential risk of participating. So this section is all about the use of the information in the study. So here you can see that participants are asked to take the box that the information they are being provided, the information I provide will be used for that specific purpose. Like in the box, you can see that you can list the planned outputs, reports, publication, all the uses, and then there are that that their data will not be shared beyond the study team. And this section on the UK Data Service Model Consent Form is related to the future uses and reuse of the information by others, and they are, yeah, it all details all the information related to the future use and reuse. I'll go through these in detail in my next webinar next month, which is related to consent issues in data sharing. But in the meantime, you can just go on our website and have a look at it. And I also added here an example information sheet outline. This is a real example from the information sheet used by a researcher who deposited data with us. And this outline shows you how detailed the information sheet is. He mentioned all the information related to the purpose of the study, why participants have been invited to take part in the study, and what will happen if they take part, what will they have to do, possible disadvantages, risks, benefits, and if there is a problem. And there is an information about confidentiality, organizing and funding, and reviewers as well. So that's a nice example as well. So that's it. So now I'll go through your questions. Yes, so yes, these, I'm not sure whether these are emailed to you or not, but these slides are present on our past events page on the website, where you can just go and download the slides. All right, so can you elaborate on the misconception that GDPR prevents data sharing? It is, there is a misconception that data protection legislation such as GDPR prevents data sharing because most of the data does have personal data in it. So it is a misconception among the researchers that if they have collected personal data, they cannot share it or archive it, but that is not the case. Because like I said, that GDPR provides you certain options. You can always anonymize that data. You can always obtain consent from the participants to share that data, and GDPR always allow restricting access so that only certain users can obtain that data. So that's the misconception. For example, in my case, I have done my PhD in psychology, and I have in all my studies, I have collected names and postcodes, and I didn't share that data because I thought at that time that because I have collected personal information, I cannot share it or deposit it with the repository. But I wasn't aware at that time that this EU GDPR or UK GDPR offer these strategies where I am able to share that anonymized data. So how long should we be keeping completed consent forms for? It depends what you plan to do, because when you deposit data with an archive or repository, we do not ask you to deposit all your consent forms alongside your research data. So it purely depends on your project, and it's always better to see what your organization, research ethics committee or research ethics officer, or there are organizational policies, what they need to say about these things. Again, I'm giving my own example. For the consent forms I have collected for my research, I was asked by the research ethics officer in my university that I have to keep this for 5 years, and then I can destroy these. So it depends, and really, you just need to ask your organization. So should researchers, participants, and researchers fill in 2 copies of consent form and then one be given to the participant? It again depends on you, that if you want to give the consent form most to the participant, you can do that. It just depends on individual researchers how they want to proceed, because you can produce 2 copies, give one to the participant and one to the researcher, or if your participant doesn't need it, you can just keep one for yourself. But I think the best practice is to produce 2 identical copies, one to be given to the participant and one to the researcher. It depends on the, I think, researchers, but the best practice is to produce 2 identical copies. I always have difficulty asking for, then there is a question. Yes, it is difficult, and people do think that it's not appropriate, but you need to explain to them. And that's why we are asking that you need to create an information sheet with as much information as you can. And you can always try to convince them that how your research can benefit, how it is in the public interest, it benefits the community. So writing these sorts of things may make their mind clear, and you can always reassure them what you are going to do with their data, that it will be anonymized, and if it is difficult to anonymize and it's too personal information in there, then you can always regulate access. So these are some of the assurances that you can offer and mention either verbally or in the information sheet. Yeah, so someone says that we encounter problems with sharing audiovisual data sometimes, and it's hard to anonymize without losing meaning, and we often can't gain consent. What should be? Yeah, so yes, it is hard with audiovisual data. It can't be anonymized. If you can anonymize the transcript, but the voice itself is considered as a personal data under the GDPR. You cannot, I think anonymization can only be done to transcripts, and the voice is still there in the recordings, which is considered as a personal data. So the best way is to regulate the access to that data. Just think about putting access that certain registered users or trained accredited researchers can only use their data in a safe environment. Then there is a question related to, if I am applying a CC license, Creative Commons license to data sets that will be archived, but all the data will be anonymous, do I still need to? I understand that you were asking that if there is a Creative Commons license applied to the data and it's anonymized, do you still need to obtain consent? No, if it is anonymized and you are sure that there isn't any identifiable personal information and it is truly anonymized, then you don't have to gain consent to share that data. So when collecting data outside the European Union, should we be complying with the local data protection laws as well as the UK GDPR? If you are collecting data outside the European Union, but you are based inside the UK, then you need to be compliant about data protection laws and the UK GDPR. And if you are based in the EU, and collecting data outside the European Union, then you need to consider the EU GDPR. And there is a question, how do you suggest dealing with unexpected findings like an underlying medical condition previously unknown? If it is not related to your research and it is unexpected, then you can always remove it. And if it is relevant to your research, then you need to decide whether you should go and ask for retrospective consent to share it or to archive it, or you need to de-identify, making it, masking it with some other information so that it's not, the person is not identifiable. You can always email me, and if you have any project related questions or you want anything, any advice on ethical and legal issues, I think I have provided my contact details on the last slide, where you can just email me. Consent forms are not anonymous, so I assume we would not need to upload those at any time. No, you don't need to. You just, if you archive, if you plan to share your data, it's just, I think, data files and the sample of the consent form used, which is blank, sample of the information sheet, and all the information, how you collected data and how you analyze it, all these logs of variables in the data files, just need, these things need to be shared or archived. Consent forms should not be shared. It's, yeah, that's right. Here's the last slide with my email address, my Twitter handle, UK Data Service Twitter, and UKDS Research Data Management Twitter handle, where if you can join these, you can keep up to date with all the events we are going, upcoming events, yeah, and latest data collections we are publishing. Thank you so much for attending this session. As I said, you can always email me for any specific project related advice. Thank you so much for attending this.